All right, hi again, Attorney Steve Vonder. Welcome back. In this video, we are talking about abandonment. Now, have you all felt abandoned before? You know what that's like. Somebody intentionally gives you away and they don't want anything to do with you and you just feel abandoned. Well, copyrights can be abandoned as well. So can trademarks, by the way. But copyrights can be abandoned, and this can be a defense to copyright infringement. It can be photo infringement, movie infringement, software infringement, all the different types of infringement that we deal with on a daily basis. So one thing that you may say is, the copyright holder has no case because they abandoned or got rid of, they didn't want it anymore, their copyrights. So let's take a look. This is from my jurisdiction, the Ninth Circuit. This covers the Western United States, Oregon, Washington, California, so forth and so on, Arizona, Utah, Montana, those kinds of things. But let's look at the defense. This is from the Ninth Circuit civil jury instructions. Let's see what it says, okay? So first of all, this is an affirmative defense. An affirmative defense means the defendant needs to raise it and prove it. You've got to raise it and prove it. If you don't, then it's no defense. But this is for the defendant that's trying to defeat the copyright holder's claim. Let's take a look. The defendant contends that a copyright does not exist in the plaintiff's work because the plaintiff abandoned the copyright. The plaintiff cannot claim ownership of the copyright if it was abandoned. In order to show abandonment, the defendant has the burden of proving each of the following by a preponderance of the evidence. Okay, so the burden of proof is on the defendant. They've got to prove this. One, the plaintiff intended to surrender. Now, it's never easy to prove the intent of another party, but you may be able to find circumstances like they posted it on a website and said, here, I hope you all enjoy it, have fun. That may be one thing. So you have to show they intended to surrender ownership of one or more rights in the work. Now, as we talked about in other videos, a copyright holder has a bundle of rights. They have the right to reproduce, distribute, publicly perform, make derivative work, so forth and so on. So you can have these different rights. You have to show, the defendant has to show the plaintiff intended to surrender ownership of one of those rights, okay? Two, there must be some overt act. Remember I said it's difficult to prove the mindset? Well, the courts are going to have a hard time going there as well. So they want to see something overt, something that happened. You see something up on a website, this is dedicated to the public dedication of this video. It's into the Creative Commons. I have publicly dedicated it. If you have facts like that, you may be able to successfully assert this defense. As it notes here, mere inaction or publication without a copyright notice does not constitute abandonment of the copyright. However, this may be a factor. These may be factors for you to consider in determining whether the plaintiff has abandoned the copyright. So one thing that you might be able to show is it was posted up on Google Images, looked like a free picture. There was no copyright symbol. I had no idea. It appeared to me that this was an abandonment. So that may be a factor when you get these copyright trolls demanding tens of thousands of dollars for, like I said, software, movies, cartoons, lyrics, whatever the case may be. Look to see if they protected it with a copyright notice. Now, you don't have to have that notice, but as this jury instruction notes, that could be a factor, okay? And this can help you when it comes down to settlement time, okay? And I'll let this read the last one here with my buddy. And, well, actually, we're not going to read that with my buddy. Okay, so anyway, note, a copyright holder can abandon one right, example, the right to copy or reproduce. They may post it up on a torrent site or something and say, have fun, distribute. That would be a great way to get the word out for your movie, but may retain another right, for example, the right to publicly display or perform the copyrighted work. So just bear that in mind. This is a quick look at the copyright defense of abandonment. Take a look at that if you find yourself against a wall in a copyright case. Okay, you can find our information there. Hope you've enjoyed the video. Take care. We'll see you again. Gotta go.